Any mention?
Yes.
May I please, Your Lordship, I beg to mention 207 of 2025 to be allowed to be listed tomorrow, Your Lordship, as there is an urgency that the bank has breached my account and I could not able to operate and I am a contractor, Your Lordship.
Can you please kindly give the case? What is the case here? What kind of mention is this? 207/2025. How is the court supposed to know what case is this? Have you made a mention memo? Do you have local counsel?
Yes, Your Lordship.
Where's the local counsel? You make it in a proper manner through a mention memo? Yes. Next.
Yes.
Please, Your Lordship. Lordship, I beg to mention item 11, Your Lordship.
11.
Yes, Your Lordship.
Hearing list.
Hearing list, yes, Your Lordship.
And for the petitioner, Lordship.
Yeah, objection.
No objection, Lordship.
No urgency.
I prayed for 2 weeks, Your Lordship.
Yes.
Much problem, Lordship.
Lordship, I beg to mention item 14 also.
And for the petitioner, Your Lordship. No objection, Your Lordship.
On behalf of private respondent, Your Lordship.
Why eating adjournment? What's the reason?
The conduct counsel is not valid, Your Lordship.
Who's the conducting counsel?
Kilitep, Your Lordship.
Who's the Kilitep? I've never seen her also in the court. Adjournment must not be taken just for fun. Yes.
Highly obliged.
2 weeks, yes. Remember that. Yes.
May it please Your Lordships, I beg to mention item number 25, and I pray that this matter may be fixed after 2 weeks as the conducting counsel is
Not well.
not well.
Mr. Kisej Gautam. This is the
Lordship, this is
What's
a
the
case
matter
where they are,
Pensionary benefits.
why pension benefits. Delay?
whether he comes under the old pension or the new pension, that is the issue, Your Lordship.
Okay, 2 weeks, yes.
Much
Obliged.
obliged.
May I please, Your Lordship? Lordship, beg to mention item number 15 and 16. It's a connected matter, Your Lordship. Item 12 and 13.
Why are you not doing these matters? Yeah,
Person-
objection,
person-
Abraham.
So they have informed, I have no objection. They have expressed the inability to. I have no objection, Your Lordship.
Where's Mr. Sinkon? He's here.
Yes, Your Lordship.
This has been repeatedly. What is the problem?
I have some difficulty today, my
What
Lord.
difficulty?
If it can be, it can be fixed tomorrow also, my Lord. I have
Not
no.
question of tomorrow. What's the difficulty?
My Lord, I have
You're
no.
not willing to pursue the matters. You would draw.
My Lord, I am very much, my Lord. I was prepared on the last date, my Lord. Leonard Senior was
You
absent.
didn't be prepared
Yeah,
today.
my Lord. Today I could not study the file.
Yes. Okay. After 1 week.
Obliged.
Highly obliged, Your Lordship.
12, 13, 15, 16.
Yes.
Yes.
Obliged.
Should I have to mention item 18? Mr. Chanda is indisposed, Lordship.
You're there.
Lordship, even I'm not kidding. Item 18. After 2 weeks.
No objection.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 27.
Your objection.
Lord, objection is there.
Your objection.
Yes.
Then we'll take
Lordship,
it up.
the conducting counsel, Mr. K. Kharaplang, he's not keeping well, Your Lordship. I just received a message. He's not. Okay.
Not like Abraham's condition that day. I hope.
Not sure.
He's very unwell and he's waving to me from the road. Yes. After 2 weeks, yes. That's correct, Mr. Abraham, right? Yes.
Supplementary list item number 1.
Are you back in station or are you still somewhere else?
Somewhere else, my lord.
Okay, yes.
We have the privilege of having our Advocate General Millets appearing internationally, Millets.
Flying Advocate General.
Millets, This is a review application against the judgment and order dated 2/6/2025, Malaj.
Yes.
Now, this is that matter, Malaj, would recollect. This is that electricity issue. Malaj, even though it's registered as a review application, the issue here, Malaj, is very limited. My lords have held, Malaj, two aspects. That the power of recall of the commission, my lords, is inherent. They have exercised that inherent power, and my lords have returned a finding at para 35 of the judgment, my lords, that there is no infirmity insofar as that power of recall is concerned. Yes. That is at, I'll just take your lordships, my lords. Page 111, my lords.
Yes.
My lords have also held, my lords, that 5 and 6, the orders of 5th and 6th passed by the commission, my lords, were otherwise bad in law.
Yes.
To that extent, my lords, in these proceedings, my lords, there is no grievance. The limited issue why this review is filed before your lordships is, my lords, this judgment does not clarify that in the absence of the orders of 5th and 6th of...
which tariff orders will operate?
My lords, that's the limited issue. Because what essentially happens is, my lords, if I can just give the timeline, what happens is, my lords, 11/4/2024, Annexure 2 to the original writ petition and Annexure 2 to the present review application before your lordships, my lords, the tariff order is passed from 1/4/2024 till 1/4/2023 till 31/3/2024. Thereafter, my lords, the single member passes that order on 6/6. Which subsequently gets recalled, my lords, after that little proceedings, the various proceedings before this court. 6/6 order is passed, my lords. First, MEPDCL comes before this honorable court, there is some interim orders passed. Then they withdraw it. I come, my lords, and your lordships relegate us to the MSARC. Thereafter, my lords, a final order is thereafter passed by the MSARC, my lords, on 23/8/2024, whereby they recall the order of 6/6.
Yes.
So the entire dispute before your lordships is, my lords, with regard to 6/6. Yes. So the only issue therefore that remains is, my lords, which is the tariff order that would be applicable for us to pay. Because insofar as the petitioner is concerned before your lordships...
There is one appeal against this order.
My lords, some people have preferred an appeal, my lords, that's coming up tomorrow, which is, I said, in these...
IA has gone in appeal, my lord. But that is also not the issue, my lord. I will show the relevant, what is the issue, my lord? Let my friend...
Let me at least finish. So, well, we are only concerned because we have paid the tariff as per the, my lords, tariff order of 11/4/2023 in so far as this entire period is concerned.
Right.
The penultimate, the ultimate order, my lords, comes on 24/10/2024. Now, one of the issues that was there in this writ petition before your lordships, my lords, this is the matter that Mr. Tiwari had argued before, my lords.
Yes.
One of the issues that was also there is, my lords, the issue of retrospective operation of the order of 24/10/2024. Now that, my lords, did not enter into in the judgment of 2/6/2024. So I am before your lordships, my lords, only to that limited issue of clarification that once 6/6 goes, my lords, the only order that would remain in operation is the order of 11/4/2024 till the order of 24/10/2024 is passed. That, my lords, 24/10 is the final order of tariff, my lords.
Yes.
Two orders, my lords, there is no dispute. One is 11/4/2023. That's the first tariff order. And the ultimate order, which now survives, my lords, is 24/10/2024.
So that's been challenged also by in the writ petition.
In these proceedings, they were challenged. That your lordships have held, my lords, that if there is anything you go before APTEL, we're not going to touch it. Right. So I am not on that, my lords. I am only on the limited issue. When 6/6 goes, my lords, the only order that would have held the field till 24/10/2024 would have been the order of 11/4/2023.
Yes.
That's the limited issue, my lords.
Yes, Mr.
Because what has essentially happened is, my lords, during this period, I have paid my tariff as per that order.
11/4/2023.
He came before your lordship challenging the order of the commission dated 23rd August 2024. Lordship, kindly see one page, my lord. Page 90. Page 90, my lord.
90.
Page
90.
Of your lordship's order. Page 90.
Yes.
You see the third line of page 90.
Yes.
As the impugned order of recall dated 23rd August 2024 and subsequent tariff order dated so are wholly without jurisdiction and patently illegal, The court therefore would examine as to whether a statutory alternative remedy provided under section 111
How
of
come my
the
90 is
Act
not tallying with
would
one?
not cases as contended by the petitioner. So only limited issue before your lordship in the writ petition was the challenge to the order dated 23rd August 2024 and 24th October tariff order, my lord. The lordship's finding, if lordship will kindly see the finding, lordship has given at page paragraph 38, page 113, my lord. The lordship's finding.
That's what I pointed out.
No, you have pointed out 35, I am pointing out 38. Page 113, my lord.
Yes.
The legality of the impugn order has been deemed necessary by this court to be deliberated and merits of the case discussed is also to discern as to whether exceptional circumstances such as breach of principle of natural justice or lack of jurisdiction exist, or there is a patent illegality present in the face of the impugn order itself that would render statutory alternate remedy negatory or futile. But as per discussion and observation made in the judgment, none exist. As such, impugn order will surely be amenable to appeal under section 111 of the City Act.
No quarrel there.
Your lordship has held. Yes. I'm just come. So your lordship has held that there is a statutory appeal. Now, in the review jurisdiction, what my friend is trying to argue a new case altogether. There is no error on the patent error on the face of record. There is no sufficient reason. There is no prayer, my lord. Which order will apply, which order will not apply. They know very well. And that was also not an issue before your lordship. So in review, in the garb of review jurisdiction, they want to rewrite the entire order, my lord. They came before your lordship against the order of 23rd August 2024, said that it is wholly without jurisdiction. Your lordship, after giving detailed hearing and detailed examination, held that it is not wholly without jurisdiction and it is for the limited scope. Therefore, now there is no occasion and no reason for them to come before your lordship. Tariff orders are there. If they have any issue, they can approach in accordance with law, my lord, but not in review, my lord. They can question all these issues, my lord.
Yes, Mr. Paul, I mean, this matter we have not touched. Only that to see, they have come, because alternate remedy is available. That's why.
My lords, para 38, my lords, as my learned.
Examine everything that.
My lords, para 38. As my learned friend has read, my lords, there is no quarrel over here.
Yes.
Which is why I said, my lords, I am neither saying touching the order of my lords 24/10/2024.
So you go to the commission.
I'm not aggrieved, my lords. I am only saying that your lordships have held, my lords, that 66 is bad in law.
Yes.
And para 38 establishes that, where my lords say that why my lords are examining 66.
Yes.
So once 66 goes, my lords, as a necessary corollary in para 35, my lords, what would have then had to come is that the order of 23 would be then applicable till, I'm specifically saying, my lords, till 24/10. I am only for that intervening period. I am neither here, my lords, I am not touching 24/10, nor am I touching anything else. I am on the premise, my lords, have set aside 66.
You want to say that the order 11/4, 23 till will be applicable till 24.
Because that's what it says, my lords. I'll take your lordships to that order. I'll take your lordships to that operative portion of that order.
That order, my lord, was challenged on the ground that it is wholly without jurisdiction, not on the ground that it is applicable.
No, I'm not. I don't know which. That order has never been challenged. 23 order is never under challenge. Page 21.
Okay, page 21. The order shall be effective 1st of 23. Remain 4th till 31st
March 20, or till the next tariff order of the commission. So next tariff order of the commission, my lords, comes on 24/10/2024. That's all.
Yes.
I don't think I'm in any quarrel with the learned advocate general anywhere, my lords.
You file it. You put on record. Yeah, then we'll pass orders.
I'm sorry, my lord.
Then put on record any short objection to the review.
My lords, may kindly give me some interim protection till then, my lords. I have been served with a disconnection notice on 21st. Let him file it tomorrow. Let him file it tomorrow.
It was not inclined, Mr. Paul, to go into this. Where's the disconnection notice?
My lords, the miscellaneous case. If my lords kindly have the miscellaneous case, my lords. Page 9.
So that there is an error apparent on the face of record, my lord. There is no error apparent on the face of record. And it's not their case also, entire case, my lord. They are trying to build a...
If my lords kindly have a look at page 9, my lords.
Yes.
This is, my lords, who have passed the order on 2nd, on 6th I am served with this notice, my lords. It says, this matter is not paragraph. I'll read the entire thing. Well, it's with reference to the subject cited above and pursuant to the order dated 2/6/2025. That's the judgment of my lords, passed by the Honorable High Court of Meghalaya and so and so. I am to inform you that an amount of rupees so and so, 2 crore so and so, is due by your company towards the tariff area payable in terms of the tariff order dated 24/10/2024, passed by MSCRC, which is yet to be cleared till date. The said amount is now outstanding for more than 5 months. Hence, this corporation demands full payment within 15 days from the date of issuance of this letter. If this matter is not resolved by the time specified above, the corporation reserves the right to disconnect the power supply and commence legal proceedings to recover the debt without further.
So you file it within 1 week?
Let them file it within a week. Well, still then, your lordship has
one objection.
They have not paid this amount for long. They have been enjoying.
Doesn't matter. You just file a small objection, Mr.
Because they are
not here also.
some stay, my lord. What I am saying,
my learned friend can also enjoy his vacation till then. Well,
they have already gone in appeal, my lord. In review, they are saying, my lord, that because they have to make out some case for prima facie case, some balance.
See, Mr. We'll pass orders. You just put on a small 2-page objection within 1 week, and we'll pass final orders. Yes.
I will do that. But let them, because we are suffering, my lord. They are not paying, and they have gone in appeal also.
Well, the fact of the matter is we've paid for that entire amount.
It's only for a differential tariff, correct? Differential amount. Anyway, so just listen to the order. You heard Mr. K. Paul and a senior counsel with so and so. This is a review application seeking review, limited review of the common order and judgment dated 2/6/25, passed by this court in WPC number 339 of 2025. 2024. Mr. K. Paul submits that the only clarification sought is to the applicability of which tariff order till the period of till 24/10.
24/10/2024.
24/10 is very clear. It is for the financial year.
Anyway, to this Learned Advocate General, appearing respondents has submitted that it is not a case for review, and prays I will have to file a small objection. Is in consideration thereof, this matter of the 1 week objection should be on board by then. Yes. In the interim, provided that the electrical connection to the
plant of the petitioner
shall not be until next date. Yes.
So much
you just file small objection, we dispose it of. We dispose of.
And they are, I'm using the money. I'm using
1 week. 1 week.
Put them to term, my lord. They have.
While it's on now that my lords have passed the order, my learned friend should also disclose, my lords, which part of the my lords, the globe is. He's enjoying his vacations.
When are you returning?
I'm 27th. I'm returning.
Okay, very good. Yes.
Still did not come, my lords.
Item number 2.
Highly obliged.
What is this?
Please, Lordship. This is Lordship. What happened is somewhere after attending the statehood, separate statehood, the Meghalaya state.
After attending statehood.
Yes. Then some
that far back.
Yeah, not part of the act. What I'm trying to say is this: some portion of land had been taken by the government of Meghalaya, particularly Forest and Social Department. That portion of land, this was known as the Rongap Achu. That was taken, and then after some years, they have handed over this portion of land to the villages and to the residents. They have grown some trees and it was known as the forest reserve, Rongap Achu Forest Reserve. That was given back to the community, to the villages, to the petitioners. Now, by the virtue of the handling over of the portion of land to the villages and the petitioners, even the other petitioners, they become the owner of that particular land, Lordship. And now what happened in the year of 2023, some portion of land had been taken by the government of Meghalaya.
It was returned. Where is that? Where is that handing over?
Yes, that is not there, but I have made a statement. No, Lordship, there are many, even there is a meeting, there is resolution now. I'm giving the history of that one. Now what happened is, after that portion of land had been taken for the construction of road. Now that that money have not been paid to the petitioner. There was only some vested interest only for the private respondent. They have some hand in glove with the respondent number, private respondent, and they are not sharing. Now only the petitioner, the grievance petitioner, yes, they also want the share of that. Yes, that is the.
Where's the paper to show they entitled to some share?
No. Earlier, yes, they have that's earlier in the year of 2013.
So
they have
handing over. You say
yes, Lordship.
Where the forest sustained by social forestry.
See, this Annex 28, the earlier order, in the earlier they have paid. In the 2023 also.
No. Listen, Mr. P.G. Sama, your case is based on your claim that there was this forest.
Yes.
Correct. There was no forest. Then the forest department taken over the land.
Yes.
They reforested it.
Yes.
And when the forest had grown,
yes,
that returned it back to you.
Yes.
Correct.
Yes.
And so only what the court wants to see is what are those supporting.
Yes, Lordship. Yes.
And this particular piece of land, which you say it's vests with your community now, has been taken over for road construction, for which you have not been paid compensation. That's all.
Yes, that's all. The poor query that Lordship exactly that the Annex 2, Lordship, the Annex 2, we have mentioned everything that we put our representation. Kindly see page 34 of Annex 2, where we have mentioned everything, and government we have submit our representation detailing all the things, but they have never responded to that. That means that maybe that there is no document, but state respondent
There's
and
only a complaint. Where's the papers to show that this land was handed to us? In which year was it given back to you?
it was long by Your Lordship, because they are not able to particularly mention those things also.
You don't know anything.
Yes, but then the record is
occupation of the land.
Yes, we are the residents.
You have homestead there.
Yes, we are staying there. It is in Kira in Songsak, William Nagar. Lordship only David praise that
we can't go on.
Lordship, that is true, of course, that there is no document. But then the state respondent, if they have the better position to tell us, because the document, everything, all the papers are with the state respondent and with the private respondent. Private respondent, if they deny, then the
private respondent?
Headman is the private respondent.
He's taken all the money.
No, we are not saying that they are going to pay only
What
to
is
the
amount
private
of
respondent.
compensation that's been
That also the villages exactly we don't know, because that question. But
who's given to?
It was given to the allegation is only to the private respondent. That is the Nogma. So our contention is that since this is a community land, they at the earlier occasion they have received some portion of the money from the.
Where's that lecture to show that the headman received money?
That is in the year 2023. Now they have not paid. I mean, it is we are not exactly whether the money has been paid or not. But
how can the court understand from where they have not paid or they paid?
No, we are saying that in case that money has not been paid.
So you want to use this court as what?
As not that is intention.
As your henchman?
Not like that, Lordship. Not like this, my Lord.
Then not like this. What?
Only is that
a petition doesn't say anything.
No, we have mentioned that we are the co-owner of that particular portion of land, and that
co-owner of Taj Mahal also. Then finished.
Lordship, it is understood, but of course there is no documentary. There is no documentary.
How secretariat and so
No. But we have approached at least they should respond to our representation. We have submitted on the 7th February 2025.
Lordship, accept notice on behalf of respondent.
Accept notice. What do you have to say on objections
Your
on law?
Lordship, even in the notice, Your Lordship, page 28, Your Lordship, the name of the petitioner.
What do you say?
This is the notice, Your Lordship, that was given, Your Lordship.
Where's the notification for acquisition?
This is the earlier notification in the year 2000. Again now this again we have come with this one.
Okay, let's see a petition. We can dispose of here only.
See, it is annexure.
Where's the notification? Acquisition.
That is annexure 4, page 63.
I'm sorry, it's not on 40, but
page 63, my lord.
And the notification?
Yes, notification is a public notice where they have mentioned that There is a public notice. Page 63. This is recently, and that portion of land for within that is there, Lordship.
It's only been acquired. It's a question of acquisition. See? This is again asking you to move yourself from there since the land vests with the National Highway Authorities.
Prior to that, there was notification and others, but we are not access to that.
This?
Yes, we are challenging to this also.
On rules of eviction.
Have
we challenged this? No.
We are challenging also. Just at least till the money is paid to us.
Think down. It's a PT Sangma. Or let's see a prayer.
Yes.
Otherwise, you can't have half-baked kind of petition like this. Yes, Mr. P.T. Sangma, the counsel of petitioner, by way of the instant petition. Submits that the petitioners are residents of a forest known as Rongrap Achu Forest Reserve. And possession of the said forest of the same had been returned to them from the forest authorities.
Yes.
When? You don't know. The date to which he does not remember or has any information of. Stop. The prayer and writ petition is for payment of compensation. Payment compensation to payment consequent petitioners and for other orders. Stop. It is noted on examination of petition noted that there is a certain public notice dated 29 April 2025 has been annexed, wherein it is indicated that wherein the district magistrate had directed for removal of all the concerned landowners stroke assets owners from the stretch of page 63 and Narangiri to Rongapari as the land vests with central government under section 3 capital D bracket 1 of the National Highways Act 1956. Stop. Next paragraph. It appears that the writ petition is misconceived inasmuch as there is no order of notice of acquisition, only a public notice directing the persons who are occupying the said land to relocate, failing which the competent authority also take appropriate action. Stop. Ms. Ailingwa is present on behalf of the
1, 2, 3, and 4, Your Lordship.
Stop. Next paragraph. Without further discussion, as the prayer seems to be misconceived and a public notice with regard to relocation of persons who are occupying government land, the writ petition are entertained.
Lordship, actually it's not government day because
yes, you have your own remedy. If it's misconceived, it's next matter.
Actually, Lordship, we have filed, we have approached the government authority, Lordship. It is there, but they have
approached the court better. Yes.
Much obliged, Your Lordship.
Yes.
Daily list item number 1.
Yes.
Lordship, I'm praying for some time in this matter, Your Lordship.
Praying for?
Some time, Your Lordship.
Time for what?
Kindly adjourn the matter for today, Your Lordship.
Adjourn application.
Your Lordship.
These matters, if he is interested in pursuing.
Well, this matter they want to pursue.
Even the score is not, if against are made, we're not passing orders also in case.
Lordship. This is stuck at that stage of 7-11, my lord.
Who's the counsel?
A.S. Pandey, Your Lordship.
What to do? When do you want it?
I don't know.
After 2 weeks, Your Lordship.
For the reasons stated in application matters, an application for adjournment has been filed by the respondent. Stop. The same peruse. Like for the reasons stated in the petition, matters stands adjourned to after 2 weeks. Yes.
Well, it's just to expedite this issue on the next date of 7-11, my lords, both parties can come with a small bulleted list, as we had prepared the matter for today, my lords.
But you will do that.
It is expected next day the no further adjournments will be taken.
My lords.
We'll dispose it of.
Item number 2.
Yes, Mr. Chanda. Filed. Fixed for hearing. Yes, sir. Parties submit the pleadings are complete. It is a matter for hearing. On so and so. No urgency. No. You dismiss. No.
He has been declared otherwise medically unfit, Lordship. So.
Okay.
Item number 3.
But I'm still waiting for instructions. I'm praying for some more time.
Lordship, this is that Section 11 petition, Lordship. The respondents.
Why? But you only said that there's an arbitrator which is agreeable, correct?
Lordship, we are agreeable, but they have.
No, but this is a very stale claim.
Lordship, this.
2 weeks time.
Further 2 weeks time is allowed. Yes. To the learned DSGI to obtain instructions with our respondents. Yes.
Item number 4.
Yes, Lordship, I am appearing through EC in this matter. As per the last order, they were directed, respondents were directed to give a reply to the petition.
You have returned the gold.
They haven't, the Lordship, and there is a development in between.
Yes.
They have been calling my client, the petitioner, since the last 1 week. They have called thrice. They wanted the bank details of the petitioner so that they can refund the value of the gold bank.
Right.
Now the problem is they have passed an order, despite the fact that the Honorable Court has passed. Now they are themselves passing an order in which they are giving the half the value of the gold bank. They are saying that we disposed it of way back 2 years ago, and we have to give that amount. As on date, they should give. There is a Bombay High Court judgment on this also, Lordship, wherein the court has held that when they are returning the gold, they have to.
Where's the order?
The Lordship, my colleague.
Yeah, where of that, Tom Mozika? No. They're returning the value of the gold on the date of seizure.
Yes, Lordship, and that is 2 years ago, and they have disposed of without that was.
No, where's the order where they're returning they want the bank details and the fixed amount?
These are annexed with this one.
That I have enclosed, Lordship. That's on page number 29 of my petition.
Okay.
In fact, 29, Lordship. 29, page number 29. And in on the last page, that is page number 33, they are mentioning the amount. 10,72,092. Whereas as on date, the value is about 21 lakhs.
When was it seized?
It was seized
Which
in
year?
2024.
23. April 23. April 23.
April 23. With the value of gold doubled since then?
Yes, Lord. It has increased considerably.
Yeah, 23. So, according to the customs, when the gold was seized 2020, the value was 10,70,000. How much gold was seized?
179. 100.
197 grams.
197 grams.
197 grams only?
Yes, Lord. If the Lordship may kindly consider the Bombay High Court judgment, if the Lordship may kindly see the last page, page number 46. The respondents were directed to restore the petitioner equivalent amount of gold, that was 1028 grams, and to compensate the petitioners by making payment of amounts equivalent to the market value of the said gold as on date. It is just because they have disposed of without the disposal was illegal, and they have misleaded the Honorable Court throughout the time 2 years when the matter was pending before this court. They never mentioned, they were never informed that they have disposed of the gold.
I'll file an affidavit. Grants me 3 weeks time.
We'll grant you some time, but in the interim, you better give the equivalent, because as on date, if the gold price is going up. Yes.
Also, I would request for a shorter date because it's just delaying this.
2 weeks,
matter.
yes. 2 weeks.
I'm paying for 3 weeks.
Nice.
3 weeks time.
Why? Customs is here.
This is the first appearance for today. Today I have returned.
First appearance today?
Well, earlier they filed, they could not serve, the commissioner has changed in between.
Oh, yes.
They are frequently changing
Dr. N. Mozika has an appearance, DSJ on behalf of the respondents. He prays for and allowed 3 weeks time to 3 weeks time to come up positively with instructions or affidavit. Yes.
Obliged.
Yes.
Item number 5.
Amit, this is your Lordship. Our Lordship, our reply has been filed and the order has been complied with, your Lordship, after the dismissal of the special leave. Lordship, kindly come to...
My Lord, that instruction, I have no instruction. They have just said, my Lord...
Lordship, kindly come to page 11. That is the type copy of the order. Letter...
affidavit file.
Lordship, yes. Kindly turn to page 11, your Lordship.
Yes.
Lordship, kindly see, this letter has been written to the Accountant General, submission of pension paper of Somat Asito. On the subject mention number.
No, but my Lord, let it come after 1 week, my Lord. I will just take the instruction of my client, my Lord. Because they have said to the AG, my Lord. Now, my Lord, again.
That means your VR has been accepted.
No, my Lord, that my Lord, since the order of this Honorable Court was there, my Lord, then they filed an appeal, my Lord. They kept everything in the...
Lordship,
then they have gone for SLP, my Lord. Lots of time has been spent, my Lord. Let me just take
also?
Yes, my Lord.
Lordship, kindly come to page 7, Lordship. That is the order of the Honorable Supreme Court.
Oh. Why?
Page 7, your Lordship. That has been dismissed, your Lordship. And then, Lordship, kindly see para 3, your Lordship. However, if the order impugned has not been complied with, the same shall be complied mandatorily within 4 weeks from today. So, your Lordship, accordingly, your Lordship, kindly see, your Lordship, page 8, your Lordship.
Yes,
liberty may be given, my Lord.
I submitted that liberty may be given. I submitted that the matter has been taken up by way of Supreme Court, which has directed that the order be mandatorily, the impugned order be mandatorily complied with. The impugned orders of this court be mandatorily complied with. He submits today that the state response accordingly has taken steps and the orders have been complied and has drawn attention to this court to page 11 of the affidavit file to show that the pension paper since been sent for process. In review of the matter, nothing is left for consideration and the contempt is closed.
Item number 6.
Please, Lordship. This matter, your Lordship, I pray some more time to file rejoinder, Lordship.
Why? It's Aking matter?
No, Lordship. Aking matter, Lordship.
You file affidavit?
Yeah, I file.
You also file? Yes, Mr. Pisa was allowed for a 2 weeks time to file a rejoinder.
Lordship.
Yes, thereafter.
What's for Lordship?
7.
This is a matter concerning sale. It's covered by the judgment of the division bench, as we pointed out.
What is this?
Well, this is regarding the
file a counter affidavit, Lordship. It was sale 2 to 19.
Oh, yes.
Risk purchase, my lords.
Yes.
Where, my lords, earlier my lords had dealt with a similar issue, matter was carried in appeal, and the law as it's crystallized thereafter is, my lords, that these are matters that essentially have to go in for arbitration.
Yes.
Lords, I have the copy of the judgment. So, the matter can be disposed of on similar lines, my lords. Both parties can go and agitate the matter. Yeah.
Our counsel is not here.
I can understand.
After 1 week.
1 week, Lordship.
Yes. With our praise was 1 week's time to obtain specific instructions or to file affidavit.
Yes, sir. This is the interim orders may kindly be good.
Interim orders, they shall cut till the next day.
Item number 8.
Yes, Your Lordship. I'm appearing for the respondent number 3 and respondent number 2 and 3. I'm yet to file my counter affidavit. A little time, Your Lordship.
When does the matter file?
It's filed in the month of May.
You file affidavit?
What's on the last occasion I have advised the court that.
You will be filing. What's the matter about?
This is regarding the land has been taken, Lordship, but there's some portion of that money is supposed to, yes, supposed to pay.
Time. Give you 1 week's further time, enough? Yes,
2
2
weeks,
weeks further time as praise allowed to the response number 2 and
2,
3. 2 and 3.
Yes.
9.
It's a 78 matter, my lord. The land was acquired in 78. This is the reason why we'll need to see the papers.
Item number 9.
What's the Lordship?
May it please Lordship, this matter, Lordship, the respondents are yet to file the affidavits.
Lordship, I pray for further 2 weeks time to file my counter affidavit.
And also, Lordship, there's a miscase, Lordship, which was filed along with the petition. But Lordship, the miscase was not taken up, Lordship. So
why was fresh? This is regarding that absent principal matter.
Yes,
Lordship.
So Lordship,
This is
in
second
the
round of
miscase,
litigation,
Lordship, in the miscase, Lordship, I'm praying for staying the demotion order, Lordship, because Lordship, if Lordship
kindly.
kindly.
One thing, Mr. Dakhar, she took part, I think.
Lordship,
in the
Lordship, she
inquiry.
took part, Lordship, but the allegation which was the allegation which was alleged against her, Lordship, was regarding that selling of that 4 packets of rice. They have alleged that she has sold the 4 packets of rice, but Lordship, in the statement, in the evidence, Lordship, she has not sold the 4 packets. It was sold by the other teacher, Lordship.
What did we challenge here?
The inquiry report and the demotion order, Lordship.
When are you going to file affidavit?
Lordship, I pray for 2
So,
weeks time, Lordship. Lordship, as on today, Lordship.
Just for the interim,
The
Lordship.
petitioner is on leave, Lordship. As on today, she is on maternity leave.
No, we're not giving any interim orders now. She's on maternity leave.
Yes, sir, she's on
Lordship,
maternity.
till August.
Lordship, that I have to seek instruction, Lordship.
Till 25/8.
Because in the miscase is there,
file
Lordship.
affidavit, and any relief you're entitled to, you'll get it.
Because prima facie,
By
Lordship,
August,
she did not
she's
sold,
on
Lordship.
maternity leave.
So that was the main.
If we stay, also she can't.
That was the
start
main
the-
allegation, Lordship. That was the
School
main
can't
allegation
suffer.
against her.
See, the school can't suffer. Is on maternity leave. How will we stay the orders then?
She's
Even
on
you have a
because-
fine case.
Till 25/8/2025, she is on leave, Lordship. She is given in application, Lordship.
File affidavit. As prayed for the 2 weeks time allowed to. Respondent number
Lordship, 1 and 2, Lordship.
1 and 2 to file. What about state?
We have performed our respondents response and not.
It's after 2 weeks.
Item number 10.
Obliged.
Much obliged, Lordship.
Though Mr. Dakhar has pressed for interim orders, the same shall be taken up at a later stage.
At the time of motion, Lordship, if I may submit, Lordship had specifically asked the petitioner's counsel if there is any miscause. He said there is no miscase, Lordship.
Lordship, there was my colleague has overlooked, Lordship, that time, Lordship. So my apologies.
Oh, is that so?
Lordship.
So actually, the miscase was filed along with the main petition, Lordship.
Then you
But-
will not be at liberty to press it.
No, Lordship, it was not taken up. It's listed today also, Lordship. It's along with the miscase, Lordship.
Lordship, and they say they will not pay.
No,
There
that,
is no.
that was not recorded, Lordship. Kindly see the order also. Nothing.
But
is
look at
recorded.
YouTube now to see what is said.
Lordship had specifically asked if are you praying for any state interim orders, and he had said no. I'm not praying, Lordship.
You moved it.
No, it was not me, Lordship. It was my other colleague, Lordship. I was not present at that day, Lordship.
His young colleague, Lordship. I mean.
So, my apologies, Lord. That's why, Lordship, I'm pressing today, Lordship, because there's
Oh,
a...
MSM Hajong moved it.
No, Lordship, it was my other
Okay,
colleague.
yes.
Most
Next.
obliged,
Obliged, Lordship.
10.
Wait, please, Lordship. I'm praying for 1 week to file my rejoinder, Lordship. To the affidavit filed by respondent 3.
What about 3?
They have filed the affidavit.
1 and 2?
1 and 2 is on board, Lordship. I have filed my, yes.
Yes, Mr. S. The principal is allowed further 2 weeks time to file agenda. Yes, thereafter.
Hearing, hearing 17.
Please, Your Lordship. Lordship, the petitioners before this court assailing the speaking order passed by the respondent.
Speaking order?
Yes, passed by the respondent.
Is the ECR matter of reconsideration again?
Lordship.
Yes.
Lordship, the ACR for 2016-17 was never communicated. In the meanwhile, DPC was convened, and due to lacking in ACR, I was denied promotion. Against that, I have approached this Honorable Court. This Honorable Court has directed the respondents to communicate the ACR and to take a decision therein, Your Lordship. Now, Your Lordship, that order will find at page 134, Your Lordship, of the repetition.
But they're not ready?
Yes, yes.
Ready?
Yes.
Yes.
Now, the relevant directions will be at page 136, para 6, Lordship.
Yes.
May be allowed to read, Lordship. In
Yes.
this view of the matter, the repetition is disposed of with the following directions. 1. The respondents' authorities are directed to formally communicate the entries made in the ACR for the period 1/9/2016 to 31/8/2017 to enable the petitioner to make representation within a period of 1 month after receipt of the same thereof. 2. The representation so presented will thereafter be decided positively within a month thereafter, taking into account the relevant parameters for consideration of promotion. 7. It is further provided that should the entries be upgraded in consideration of the representation, taking into account the petitioner's earlier track record, the respondent authority shall constitute a review DPC for grant of constitutional reliefs, if any, on the basis of the above. The entire exercise shall be completed in a period of 5 months from the date of receipt of representation. Now, pursuant to this order, Your Lordship, I have preferred my representation, and the respondent authorities had taken a decision and passed a speaking order on 30th November 2023.
Where is that?
Page 156.
So you mark above average?
Lordship.
In that in the ECR?
Lordship. I've been graded high average, Lordship.
High average. Where's the impugn order?
Page 156.
Okay. Yes.
Now, para 1, 2, 3, 4 are basically a facts, Lordship. Paragraph 5 will be the observation part, discussion. Paragraph 5, Lordship. Now, therefore, in compliance with the judgment and order dated 24 August 23, the representation of so-and-so has been considered by the competent authority, keeping in view the following aspect. A. Benchmark for performance appraisal for promotion and benefits in the modified assured carrier scheme has been enhanced from good to very good by the Government of India, Ministry of Personnel, Grievances and Pension.
From good, average to very good. Yes, okay.
By the Government of India, Ministry of Personnel, Public Grievances and Pension, dated 27 September 2016. Accordingly, the policy has also been implemented in the Assam Rifle with effect from 1 January for grant of promotion and benefits of financial upgradation under modified assured carrier progressive scheme by Directorate General Assam Rifle letter number dated 20th November 2010 and dated 29 December. As per the policy, all employees are required to earn at least very good above average in Assam Rifle in all annual confidential report from the year 2016 onwards. So basically the required benchmark is above average. B. In the instant case, the petitioner came for promotion to the rank of Subedar as per his seniority in the year 2021 and in 2022 and was screened by a departmental promotion committee along with his batchmates in the year 2021 and into 22. However, the petitioner was found to be ineligible for promotion due to lacking in annual confidential report criteria, as was found to have been graded high average, that is 5 points, in the annual confidential report for the year 2016-17. Whereas to become eligible for promotion, he should have been graded above average or outstanding. Therefore, he was superseded for further promotion. So basically the required benchmark for 2016-17 for me to qualify for promotion, that I should be graded with high average, that is above average, that's 7 points, or
So
outstanding
makes
points,
you ineligible.
which makes me ineligible, Lordship.
Then?
C. On perusal of the annual confidential reports of the petitioner from the assessment year 2001 to 2022, Lordship,
Yeah.
it has been revealed that he has been graded average 2 points in the annual confidential report successively for the assessment year 2007 and in the year 2008, while in the rank of Havildar General Duty, and high average in the rank of Subedar in the annual confidential report for the assessment year 14-15 and 16-17. Assessment and grading awarded in the annual confidential reports by officers and reviewing officers are purely based on the performance during the assessment periods. Hence, award of 2 consecutive average grading in the rank of Havildar and high average grading twice in the rank of Naib Subedar have been taken into account, which clearly reflects the poor performance of the petitioner. So what they have done is they have taken into account the years from 2001 to 2022. While considering my representation, they have considered these relevant years, Lordship, which are not at all relevant, Lordship, for consideration, to consider what is the required benchmark for promotion, Lordship, because the relevant years will be 5 years, Lordship, not the earlier track, not the earlier records, Lordship. So now they have gone into when I was posted at Havildar. They have gone into when I was a now they have taken all the considerations, Lordship.
They will consider more than what is directed also.
More, Lordship.
Then?
Now 6, Lordship. And whereas on careful examination of the entire service records of the petitioner, it is revealed that the performance of the petitioner during his service was not satisfactory, due to which he was rightly graded high average 5 points by his reporting officers during the assessment year 2016-17. Hence, he was not eligible for further promotion and rightly superseded for promotion to the maximum higher rank, Subedar, by a duly constituted departmental promotion committee. Now, therefore, in light of the facts and circumstances enumerated in the preceding paragraphs, the competent authority, after detailed examination of the representation of the petitioner dated 22nd September 23, is of the considered view that the request of the petitioner to upgrade his annual confidential report for the assessment year 18-17, should be 16-17 also, and consider his for promotion to the rank of Subedar lacks
What's
merits.
18-17?
There's a typographical error, it should be 16-17. And to consider him for promotion to the rank of Subedar lacks merits and substance. Hence is hereby rejected, as high average grading awarded to the petitioner in the annual confidential report is purely based on his performance at that time. Furthermore, the performance of the petitioner during the assessment year 2007, 2008, 2014, 15 are also below the benchmark. Now, Lordship, they have not even considered the required relevant years, but they have gone into the entire service record and rejected my application.
No, but one thing, Mr. Nompur, the fact that remains is that policy says that for 16-17, correct?
Yes.
It should be
high average,
above average, and your high average. So you don't have the required points.
Not yet.
It should be 7. You got only 5.
I got only 5.
Then, so what grievance you have now? You don't need
Why?
speaking order anymore. So they communicated to you, then they didn't expunge it, correct?
They didn't expunge
because
it.
the thing is that with representation against ECR is that is communicated to you that you've given high average.
No, sure.
Okay. And then so you're represented against that. Where's the representation against the gradation of high average?
Representation is here, Lordship.
That time this court allowed you to directed them to supply the
to communicate the ACR, Lordship.
The remarks, correct?
Yes.
Communicated, you represent against that.
I filed my representation.
So this is the
order
representation.
Lordship. Lordship, can you come
but
to
it has not also touched upon why
exactly, Lordship.
Why is not why it doesn't deserve expunging.
Lordship, before coming to that, because my ground is that while passing the impugn order, Lordship, they have not specified any reason why my application should be rejected. Now, kindly come to the ACR, Lordship.
No, ACR now. Where is your representation?
My representation is at page 144, Lordship.
Okay. Against that, for expunging the
for upgradation of my ACR, Lordship.
Expunging, sorry, upgradation. Yes.
144 is my representation.
Yeah. So they have based the non-upgradation SER on your past performance.
On my
That you
past-
say is illegal.
That is illegal. That is one of the ground, Lordship.
Then?
The second ground, Lordship, they have not specified any genuine reason, any valid reason as why my application should be rejected. Why my application was rejected. Now, can you come to the ACR, Lordship?
Page
82.
Yes.
Page 82 of my writ petition.
'85, '82.
82 is the ACR, but 85 will be relevant. Lordship. Now 85, there's a para 15 in Lordship, pen picture. Now this is my ACR for the year 2016-17. Now the IO has graded me 7, Lordship. Now
The
then
reviewing gave you 5.
the RO gave me, RO graded me 5, and then the SRO graded me 5 again.
Yes.
So now in the impugn order, Lordship, there's no specific reason that indicate that why I was graded 5, why I was downgraded from 7 to 5, Lordship. What was the reason behind all this?
Reason given here, high average GCO. I agree with the assessment of the reporting officer.
The IO is liberal.
For the reviewing officer, the initiating officer liberal in his assessment.
Lordship, kindly see when
that means that does it mean that they examined your past records from 2001?
Lordship, kindly see when did the SRO had signed the
2019.
ACR, Lordship? 19, after 2 years, Lordship. After 2 years.
Do you have any authorities?
So far as speaking order is concerned, Lordship, it's
No, we're not speaking order with regard to what is in ACR expunging or upgrading, but the thing is whether they can go and look into the entire track record. What that you're saying is not permissible.
Lordship.
Correct.
Lordship.
You said for consideration of promotion it should be those 5 years.
Only 5 years.
And for 16-17 you have only 5 points.
Lordship.
And so the non grant of 7 points for you, that's the only thing. Yes, but they have not.
Lordship,
What do you have to say? Yes.
So you will see here in this the petitioner is coming this first of all he was reading that his ACR was not communicated. So
that's
then,
over.
then after
that's finished.
that's
That's finished. It was communicated. He's been communicated. The remarks communicated. He's represented against that. You've passed a speaking order saying that no, we can't allow him. His track record is very bad, and since for that relevant year 16-17 to require above average, he got only high average, so he can't be considered promotion. What other submission they have to make?
So now my submission is there.
How do you defend your order?
You will see here why last question could just question me one matter. Why we have taken the ACR for 2001 onward. So you will see. So you will see here page 137.
See, only thing is that the courts will find that your order is based on some valid reasoning. That's all. And if the court says pass speaking order, that means it should address all the issues which have been raised by the petitioner. That's all.
So you will see here on page 137 of the petition. You will see.
Yes.
Paragraph 7 of this judgment of the earlier judgment. You will see. It is further provided that should the entities to be upgraded in consideration of the representation taken into account the petitioner earlier track records. So you will see it is not only for 15-16 and 16-17. The department should have considered this all tracking. So that's why 2001 onward whole record is taken into consideration. There is nothing wrong to go behind the 15-16, 16-17, 17-18.
Yes.
So taking into consideration the judgment, you will see the petitioner's earlier track records. So taken into consideration all.
Yes.
There is nothing wrong to mention these earlier years. in this respect the matters. So this is my submission, Your Lordship, on this matter.
Where in speaking order?
Speaking order is type copy, this one.
Para 8, Lordship, page 158. Page 158, para 8, Lordship. The speaking order dispose of the representation dated.
No order of this court asking speaking order?
Orders of this court, Lordship, will find at page 134, Lordship.
134 does not say speaking order.
To pass
now
a
just come back to your track record from 2001 to 2022.
Lordship, that is not even relevant. Lordship,
No, come back to that. That's what he's saying.
Kindly come to page.
Come back. There's one release also. Sorry. Where's that one? Where's the type copy of that order?
Page 157, Lordship. 157. (5C), Lordship, 5C.
After the years, I think 14, 15 was high average. Yes.
Lordship, kindly come to 106, Lordship. Page 105. This is the required benchmark for promotion, Lordship.
No, that's fine. But we're just looking that you had only high average in the other years also.
Yes, Lordship.
That is why. So that's why they're looking at the earlier years in high average in from 7, 8, so on. High average, and so they maintain the high average only.
But there's no reasoning, Your Lordship. In the speaking order, there's no finding. Why I was downgraded 5 grades, Lordship, 5 points, Lordship. Lordship,
that's very liberal. That's what he said.
Lordship,
looking into your earlier.
Lordship, and that ACR was signed in the year 19 after 2 years. Lordship, kindly come to page 105. This is the required benchmark. This is dated 29 December 2016. Now the relevant, so far as concerning the petitioner, Your Lordship, page 107. 107. They have prescribed what is the benchmark for DPC 2021 onwards.
Where is that?
Page 107, okay. Lordship. For DPC 2021 onwards, the petitioner is supposed to be promoted from Naib Sobedar to Sobedar. So all 5 ACR should not be below very good, above average, 7 points. Lordship, kindly come at the table at para 3. 5 years, Lordship. That means for promotion, for my promotion for my application to consider for promotion.
What about 14, 15? You got very good.
Very good, Lordship.
In 15, 17?
15, 17.
From 12 to 15 you got
12?
Yeah.
Lordship. No, Lordship, this is a general prescription.
No, last general prescription.
Yes.
What was it from 12, 13, how much? What was the grading?
12, 13, Lordship, I'm not aware to that because they have not communicated that to me.
14, 15?
So the relevant required benchmark is from the year 2016, 17, 18, 19 and 20. You kindly see it.
Okay, 15, you got what? Very good.
Lordship.
Or 15, 16 you got?
15. Lordship, I got very good, Lordship. No, Lordship, I got average, Lordship. I got only 5
Average
5
is
points.
2.
Average, Lordship.
Average is 2.
Lordship.
High average is 5.
5. And above is 7, Lordship.
Above average 7. Okay.
7. So basically, I like ACR for the year 2016-17, Lordship. Why I'm showing this table, Lordship? To show that to come to the zone for consideration, Lordship, for promotion, 5 years are relevant, Lordship. 5 years for DPC 2021. That means from 2016 to 2020. Those are the relevant years.
Yes.
Which the respondent should take into consideration, not the earlier records.
Fine. Now 16. No. For post upgradation, is that a question of upgradation and promotion are two different things, Pure. Upgradation is that the basis of your track record will be taken consideration for upgradation. Basis of promotions, after they've considered the upgradation, whether it can be done or not, then suppose they upgrade you, then the last is 5-year ECR will be looked. It's two different aspects. Upgradation of ECR, okay, track records they've looked into. They said court orders track record, they've looked at the early track record from 2014, 15, they seem that you've got average only. Fine. Now, upgradation, they'll consider, suppose this officer has got a consistent, high, very, what do you call it, above average. So his, downgrading in 16-17 to high average is, not based on any materials. So the court has said that fine, for consideration, since they were not communicated to you, communicate them to you, and you be able to represent against the the grading that you've been given. And if they upgrade you, then the question of considering promotion from 5 to 6 will come, not a question of upgrading. You understand that? That's a fine distinction.
So far as my understanding,
you look, get some authorities, we'll give you some time. What upgradation and what is consideration for promotion?
Because I'll come back.
You come back, we'll give you opportunity. It's an interesting case also. Because whether the authorities are at liberty to look the entire track record, because if there's a dip, suppose an ACR of a person is consistent, suddenly some officer comes in the middle to the person. It happens in all corporations or in government institutions. He's been having consistently very above average or excellent, outstanding. Suddenly an officer comes, doesn't like his face, he becomes good. Then that good, spoils his chance of promotion, right, or further in his career. Then when that good is there, what happens when it's communicated to the officer, he represents against that. He represents, goes to the authority that, the command authority will see. He said, yes, that's not based on any, it's not on the basis of his performance. Because his performance of his officer is consistently, above average or outstanding. So then on those considerations, they'll expunge that or upgrade your ECR. And after upgrading ECR, on the findings that they've arrived at, then they will take consideration the 5 years necessary for promotion next grade and see, okay, fine, since we have upgraded the 16-17 to outstanding, so he's eligible for promotion, then they'll promote you. That is a distinction.
Lordship, there are judgments from Supreme Court.
Yes, you kindly.
By relying on Sukhdev Singh, Lordship, they have said that uncommunicated ACR could not have been relied upon by the respondents.
No, that is different. That is a different aspect. You bring some authorities with regard to upgradation and with regard to consideration of this. Yes, let's for further hearing after 1 week.
1 week.
19.
Granted time to file the affidavit, no. In this matter, Melod's on Mahapre had permitted us to file the affidavit, Melod's. There seems to be some confusion with the notification. That
why? What notification? What confusion?
Melod's, the notification that we had, essentially, Melod's, is not the notification that we were originally Melod's, referring to by in these proceedings, Melod's. I have a copy. I just place it for Melod's. Because even under this, Melod's, we would be eligible, Melod's.
Which one you want to replace? Which notification? You have it with you.
Melod's, unfortunately, there seems to be some confusion with regard to the notification. That's why, Melod's, we were not able to file the affidavit.
We'll give you 1 week's time.
Melod's, I'd pray for that, Melod's. I apologize for the inconvenience.
Yes, Mr. submits that notification. The particular notification could not be obtained. Yes, in time. He prays and allowed further 1 week's time to put in the same on the record.
19 to 23.
18 to 23. 19 to 23.
23.
24.
Oblige.
Yes.
May I place a motion?
Where's the voice coming? Yes. Yes.
Lordship, the The petitioner is a private limited company, which is basically
I
working
can't
as
see
a
you also.
vaccination center as per the
You're not visible.
There is an issue with the camera. My video is on, but I am not visible for some reason, my lord.
You fix it. List it after on Monday.
Who please, my lord?
Yes.
26.
May I please, Your Lordship? Your Lordship, conducting counsel, Mr. R. Gurung is on his legs before the division bench. Your Lordship, number 2 item.
What's the matter about?
This pertains to Militz. I'm sorry, Militz.
Pension matter?
No, Militz. This is regularization of service, Militz.
He's still serving or he's?
No, he's not, Militz.
Post facto?
Post facto, Militz, because he was Militz since 2006, Militz, he was there.
After 1 week?
Yes, Your Lordship. Much obliged, Your Lordship.
As a High Counsel for the response of eligible, this is a matter up to 1 week. He's finishing right now or he's still continuing the case?
Number 2, Your Lordship.
He's been on legs, matter's been going on for a while.